Lewis, number 5 here. We've had some recent discussion about your concerns that the older Dred Scott versus Sanford case may be still on the books and causing case law precedent, which is giving color of legitimacy to brutal jackbooted Nazis, prioritizing the abuse of black people more than they abuse white people. Did you want to give an outline of how our discussions and thoughts are bringing this agenda item together?
Sure, I will do. And as I believe that words matter, I will try to be as accurate as possible in my speech. I must say again that typically I do not refer to people as slaves or even enslaved, but I will for the purposes of this dialogue. I believe, based on my education and research, that those people were in fact prisoners of war. So for those on the call that may say, well, what war was that? I'm referring to the War of 1591 on the Songhai Empire of Western Africa by the Moors. So when I use the term black, I'm again, for the purposes of this dialogue, I'm talking about a very specific people, okay, the descendants of the people of the Songhai Empire, not to the amount of melanin in one's skin, and that's kind of been expanded. So I'm not talking about the Moors, I'm not talking about Hebrews, I'm not talking about the tribes that were here, most of which would have been considered black in color, of course, before the existence of the $5 Indian, but I'm referring to a specific people. And let me also say, before I summarize, that anything I say, I am not minimizing the fact that, specifically by police, that all people have been abused. Just using as last year, 2020, as a talking point, there were 1,004 people that were killed, unarmed, by current or former police officers. Now, 43% of those were white. And again, for the purposes of this conversation, when I say white, I'm referencing those that may have been from European descent, or might also be referred to as the Anglo-American. 43% were white. 38% were black or brown people. 28% specifically black. And when you find that we are only 13% of the population, you see that the numbers are disproportionate in terms of black and brown people. And all the people that I will discuss were not necessarily killed by police. And so sometimes it came to the point of white people in general feeling that they are justified in killing black or brown people. And I do go back to both the Dred Scott versus Sanford decision, as well as the original proposed 13th Amendment, some 7 years later. So I believe that if we are really, truly looking to heal the long history of systemic racism so that all Americans have the equal right to live and pursue happiness, this is something that needs to be addressed. For years, elected leaders have failed to acknowledge this war of white aggression was even real, even as the bodies of innocent people have continued to pile up. So as a result, a critical mass of white people, in my opinion, have fears about multiculturalism and progressive politics and, of course, the equitable distribution of power because they believe that it would spell their obsolescence, erasure, and or even subjugation. And so it needs to be, and that fear is often exploited by those in power. And I believe that something must be done to stunt that. So what you have on screen here is just from the Wikipedia link that Charles included in the agenda. And I'm not going to go through this, as I'm hoping that most are familiar with this decision, or will take the time to at least read the summary that Wikipedia gives. But Dred Scott had 2 attempts in the Supreme Court. And his first attempt was in 1846, which was actually dismissed on a technicality, but he used as his legal arguments some precedents such as Somerset versus Stewart, Winnie versus Whiteside, and Rachel versus Walker. In doing my study of this, I found out that there were some 300 or more of these such cases. He was simply just the most famous. So I had to take a look at, Somerset versus Stewart, which goes back to England. And this one was a judgment in the English Court of the King's Bench in 1772, related to the right of an enslaved person on English soil not to be forcibly removed from the country and sent to Jamaica for sale. The case of Winnie versus Whiteside was actually the first freedom suit heard by the Supreme Court of Missouri. And when they won this case, the petitioner, in fact, won this case and established a precedent that a slave remained free once they'd been taken. She'd been taken into the Michigan territory at the time, where obviously slavery was illegal and unlawful. And then once again returned and petitioned the Supreme Court of Missouri and won. So therefore, the phrase "once free, always free." So he leaned on this case as well as a precedent. And then lastly, Rachel versus Walker, another freedom suit, once again in the St. Louis Circus Court. So Missouri was always a hot spot, if you will, for these freedom suits. And as I mentioned, there were some 300 of them. But it was the Supreme Court, and Roger Taney specifically, that made this statement, in his opinion, as so far inferior that they had no rights which the white man was bound to respect. That line, I believe, goes throughout not only police enforcement, but I also believe that subconsciously, that is why we have all of these calls from those comically called Karens who may dial 911 because you've got a black child selling lemonade on the sidewalk in front of their apartment, or you have a black man that is bird watching, or you have one that is simply studying in a commons area of a dorm where she resides and get the police called on them, or simply someone sitting in a Starbucks as a group waiting for someone else. I believe that this line is at the root of that. Outside of the Dred Scott decision itself, I believe that the original, and which history teaches, that it stood until the 13th and 14th Amendments. So because we are looking to reestablish and reform, reimagine, if you will, the Republic, I believe that this needs to be addressed, and I will be authoring a complaint over the upcoming weeks. When taking a look at the original 13th Amendment, one finds that if you take a look at not the 13th Amendment, which was actually passed, but what was proposed in 1864, again, 7 years after the Dred Scott case, you see, and I've got on screen here, this is from the Library of Congress, you see that the original proposed 13th Amendment had 20 sections. 20 sections, not the 2 that it has now. But it gives some insight into the thinking not only of the Supreme Court, but of the Congress while proposing the 13th Amendment. And it addresses in several sections citizenship. Okay, and specifically, let's go to the next image here. Section 12, where it outlawed the slave trade. The traffic in slaves with Africa is hereby forever prohibited on pain of death, and the forfeiture of all the rights and property of persons engaged therein. But it also went a step further and said, and the descendants of Africans shall not be citizens. It addressed the African descendant again in Section 17. We had mentioned Congress may assist free persons of African descent to immigrate and civilize Africa. Now, there was a dissenting opinion which stated that several of the states did, in fact, consider the descendants of Africans citizens. But again, that was a dissenting opinion. But they named, the Massachusetts, the New Hampshires, the South Carolina, which did as well, and several others. But what stuck was the opinion delivered by Taney, and I believe that to this very day, either consciously or subconsciously, is within the minds of the Anglo-Americans or European Americans. So it is very clear to me why the 14th Amendment citizen, which is in fact a thing, a creature that, of course, of the federal district state, needed to be created. I'm of the belief that a 14th Amendment citizen is not a human being, however, a thing, okay, that is enjoined with the human being and specifically for their protection. Charles and I had a conversation regarding this matter, which he suggested to me that I kind of pare down the number of instances of some modern black person that has been the victim of this. And that's challenging to me. And I've even looked out to others for assistance because I can't get any lower than 6. I started with over 40. And these were people that have actually been killed, in my opinion, due to this. Not the ones that there are hundreds or thousands more, if not millions more, that may have survived the encounter. But these are ones that have been killed from everything from failing to signal a lane change, such as Sandra Bland, riding in a car, Philando Castile, selling cigarettes outside of a corner store, riding a commuter train, walking home with a friend, making eye contact with a police officer, selling CDs outside of a supermarket, walking away from police, walking towards police, missing a front license plate, playing with a toy gun at the park in the case of a Tamir Rice, driving with a broken brake light. One man killed sitting in his, yes. Sitting in his car. Go ahead.
Can we try to move it along? I was hoping to, I think one of the main issues that we do need to focus on is, I think it might be difficult to figure out what people are doing subconsciously, but I think what we can tangibly address through our court process here is if there might be some residue of the Taney evil decision there that is still, like I think we agreed on wording earlier, supposedly on the books.